Rule 17, annotation. Rule 17, annotation. Law reviews. For article, the ethics of contacting witnesses. For article, the ethics of contacting witnesses. December 2017. December 2017. A defendant is not entitled to issue ex parte subpoenas duces tecum by leave of the court. The Fifth and Sixth Amendments to the federal Constitution do not give the defendant the right to engage in this type of discovery without providing the information to the prosecution. People v. Baltazar. Colo 2010. Effect of failure of subpoenaed witness to appear under some circumstances. Failure of court to grant continuance or to order mistrial when witness who has been subpoenaed fails to appear requires reversal. People v. Lee. 180 Colo 1973. A trial court does not abuse its discretion in denying a continuance because the defendant's psychiatric witness who had not been served with a subpoena failed to appear. People v. Mann. People v. Mann, Colorado 1982. Order of court should be required before a subpoena duces tecum is issued. Digi Leonardo v. People. Digia Leonardo v. People, 1971. During the course of a criminal prosecution, the prosecution may compel production of telephone and bank records through the use of a subpoena duces tecum so long as the defendant has the opportunity to challenge the subpoena for lack of probable cause. Use of a subpoena duces tecum for such records is not an unreasonable search and seizure provided that it is supported by probable cause and is properly defined and executed. People v. Mason, Colo 1999. Probable cause for issuance of a subpoena duces tecum for obtaining telephone and bank records exists if there's a reasonable likelihood that the evidence sought exists and that it would link the defendant to the crime charged. People v. Mason, Colo 1999. District attorney has standing to challenge defense subpoena of third party as the prosecuting party. The district attorney has an independent interest in ensuring the propriety of third-party subpoenas as part of the management of the case and the prevention of complainant or witness harassment through improper discovery. People v. Spykstra, Colo 2010. To withstand challenge to criminal pretrial third-party subpoena, defendant must demonstrate 1. A reasonable likelihood that the subpoenaed materials exist by setting forth a specific factual basis. 2. That the materials are evidentiary and relevant. 3. That the materials are not otherwise procurable reasonably in advance of trial by the exercise of due diligence. 4. That the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And 5. That the application is made in good faith and is not intended as a general fishing expedition. People v. Spykstra, 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 Colo 2010. In addition to this basic test for subpoenas issued for materials that may be protected by privilege or a right to confidentiality, a balancing of interest is necessary, and the defendant must make a greater showing of need. In-camera review may be necessary in some instances, but is not mandated. People v. Spykstra, Colo 2010. District attorney has standing to move to quash defense subpoena of alleged victim to appear at preliminary hearing. The district attorney has an independent interest in ensuring the propriety of subpoenas and in preventing witness harassment. People v. Bros, 2013. Trial court abused discretion in failing to rule on motion to quash witness subpoena prior to preliminary hearing. Court may quash witness subpoena prior to hearing prosecution's evidence at preliminary hearing with respect to a defense subpoena of a child victim. The prosecution indicated that the child's testimony would not be required for the probable cause determination and that the child could suffer harm by preparing for and attending the preliminary hearing, even if not ultimately required to testify. People v. Bros, 2013. Witnesses for indigent defendants. The expenses of obtaining the testimony of witnesses for an indigent defendant must be paid by the state. People v. McCabe, 1975. Defendant must establish indigency to satisfaction of the court. People v. McCabe, 1975. Defendant must establish indigency to satisfaction of the court. People v. McCabe, 1975. No authority to quash properly issued subpoena. There is no authority under this rule to quash a subpoena if the district attorney has complied with the technical requirements. People v. Insur. People v. Insur. Colorado Appeals, 1981. Mailing a subpoena to a witness without more does not comply with the requirements in Section E. The record does not indicate that the prosecution exercised diligence in trying to obtain the witness's presence. People v. Stan Chief, Colorado Appeals, 1993. STAN CHIEFF, subpoena served by mail insufficient to invoke contempt. A subpoena served by mail pursuant to an administrative order is insufficient to invoke the sanction of contempt under Section H. People v. Mann, Colorado, 1982. For in-camera examination of subpoenaed bank records, see Pignatiello v. District Court. Pignatiello v. District Court, Colo, 1983. Discovery cost. Prior to requiring the public defender's office to pay cost of copying a police officer's file for an in-camera review by the court should make the following specific findings. Was the defendant's subpoena unreasonable or oppressive, and were the city's proffered concerns as to use and possible loss justified? The court should consider whether adequate safeguards could be provided for an initial in-camera review of the original documents and whether any payment should be limited to actual cost. In doing so, the court must balance the government's interest against defendant's interest in disclosure. People v. Trujillo, Colorado Appeals, 2002, reversed on other grounds. Colorado, 2004, applied. People v. Duncan, 1972. AV District Court, 1976. And Lo Savio v. Robb, 1978. And there you go. Those are some annotations for Rule 17. Rule 17, subpoena.